The Lawyer's Code of Professional Responsibility was promulgated in June 21, 1998. It is known and considered as one of the most important and integral parts of the subject known as legal and judicial ethics. Code of Professional Responsibility has 22 canons. And according to these canons, the conduct of a lawyer should be guided by their fourfold duties. These fourfold duties are the duties of a lawyer to the society, the duties of a lawyer to the legal profession, the duties of a lawyer to the court, and the duties of a lawyer to the clients. In this four-part video, we will dig deeper into the meaning of each canon. We will also be discussing cases because I believe that looking at these real-life current examples is one of the best ways to keep learning about some of the professional responsibilities pitfalls and how to avoid them. The canons from 1 to 6 will cover about the duties of a lawyer to the society. Canons 7 to 9 will cover about the duties of a lawyer to the legal profession. And then from 10 to 13 will cover the duties of a lawyer to the court, and then from 14 to 22 will cover about the duties of a lawyer to their clients. Okay, so let's start. Canon 1. A lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law and legal processes. Let's look at the case between Barrientos versus Attorney Libran Meteoro. In this case, Attorney Libran Meteoro issued several checks as a payment of her pre-existing debts. Apparently, these checks bounced because of insufficient funds. Barrientos and Mercado filed BP-22 against Attorney Libran Meteoro. And Attorney Libran asked for the deferment of the criminal charges and promised to pay her debt. However, she failed to do so. So the question is whether or not Attorney Libran Meteoro is guilty of gross misconduct. Well, the Supreme Court ruled in affirmative. According to the Supreme Court, the deliberate failure to pay debts and the issuance of worthless checks makes the lawyer guilty of gross misconduct. So Attorney Libran Meteoro was suspended for 6 months. Another case that we need to read to better understand Canon 1 is the case between Mecaral versus Attorney Vasquez. Mecaral is Attorney Vasquez's former secretary who became his lover and a common law wife. And in this case, it said that the complainant was brought to a mountainous region of Biliran and was left behind in Faith Healers Association of the Philippines. It's a religious group which is headed by Attorney Vasquez, the respondent. With the instruction of Attorney Vasquez, Mecaral was tortured, brainwashed, and has been injected with drugs. She was in captivity until her mother, aided by the police, rescued her. So, what did Mecaral do? She filed a disbarment case against Attorney Vasquez. Okay, so what is the Supreme Court's ruling? The Supreme Court disbarred, and the name of Attorney Vasquez was stricken out from the roll of attorneys. Why? Because Attorney Vasquez has violated Canon 1, which says that a lawyer shall uphold the Constitution, obey the laws of the land, and promote and respect the legal order and processes. And for Canon number 2, it says that a lawyer shall make his legal services available in an efficient and convenient manner, compatible with the independence, integrity, and effectiveness of the profession. So what does this say? Canon 2 explains that a lawyer shall not reject the cause of a defenseless or of an oppressed person. except for valid reason. And if the lawyer does not accept the case, he or she should not refuse to provide legal advice to the person, if only to the extent necessary to secure the person's rights. And the lawyer should not charge rates lower than those customarily prescribed. One case that will help us understand Canon 2 is the case between Dominador Burbe and attorney Antonio Magulta. Okay, so Dominador Burbe is the petitioner, and he filed a complaint against Antonio Magulta, who is the respondent, of course. And the complaint is for disbarment, suspension, or disciplinary action against the lawyer. The story goes this way. The respondent is supposed to represent the petitioner on a case, on a money claiming case, and also a possible civil case. And the respondent asked for a payment amounting to 25,000. That is for the attorney's fee and for the filing of the case fee. The petitioner paid the 25,000 to the respondent. Several months have passed, however, but the respondent still cannot provide an update regarding the case that he is supposed to file. So the petitioner always asked him about the update, but the respondents keep on telling the petitioner to just wait. In order to prove his claim, the respondent brought the petitioner to the Hall of Justice in Ecoland, Davao City. And the respondent, requested for the petitioner to wait for him for several hours, only to tell him that the clerk of the court is absent. So, meaning to say, he still did not provide any result. What the petitioner did is he went directly to the Hall of Justice to ask if there's indeed a case filed by the respondent. And to his surprise, there was nothing. So he confronted the respondent, but the respondent still denied the allegation. He only accepted his fault when the petitioner provided a copy provided by the Hall of Justice indicating that there is no filed case by the respondent. So that's what happened. Okay, so the question is whether or not attorney Antonio Magulta should be disbarred. The court adopted the Integrated Bar of the Philippines recommendation. There was a lawyer-client relationship established because the respondent already agreed to represent the petitioner, and the petitioner already paid the 25,000 pesos payment for the respondent's service and for the filing of the case. There is an obligation on the part of the respondent to file the complaint within the time frame. In addition to that, there was a misappropriation of funds. His actions caused damages and prejudice his client. His conduct is dishonest, thus unsuitable to be a member of the legal profession. He was not disbarred, but he was suspended for the practice of the law for a period of 1 year. For Canon number 3, it states that a lawyer in making known his legal services shall use only true, honest, fair, dignified, and objective information or statement of fact. In the case between Pedro Linsangan and attorney Nicomedes Tolentino, the complainant filed a case for disbarment against the lawyer respondent because of solicitation of clients and encroachment of professional services. According to the complainant, the respondent is trying to steal his client by telling them that he will be providing financial assistance. And the complainant also secured a copy of the respondent's calling card with a clause or words that says providing financial assistance. So the question is whether or not the respondent lawyer is violative of the Canon 3 of Professional Code of Responsibility. The answer is yes, because lawyers should only use true, honest, and dignified statement when promoting himself or his or her services. The clause with financial assistance in Attorney Nicomedes Tolentino's calling card is a way of commercializing the profession, the law profession. Its purpose is to entice clients to change counsels through the promise of loans, and it's not a fair way to advertise your service. Lawyering is a profession and not a business, and lawyers should not advertise their talents and services in a way like merchants advertise their wares, because it cheapens the profession. Alright, so let's go to canon number 4. Canon number 4 says that a lawyer shall participate in the development of the legal system by initiating or supporting efforts in law reform and in the improvement of the administration of justice. Example for number 4 is presenting position papers or resolutions for the introductions of pertinent bills in Congress. Let's take the case between Binalay versus Judge Lilina Jr. In this case, Attorney Binalay filed an administrative case against Judge Lilina Jr. for violating Rule 138 of the Rules of Court and Canon 4 of the New Code of Judicial Conduct. Both are with regard to the prohibition on judges in the private practice of law. Respondent judge is preventively suspended for being charged with rape, abduction with rape, and slight illegal detention. While in suspension, the respondent judge has engaged in a private practice of law representing 2 persons for a criminal cases and 1 person for a civil case. All pleadings in those cases were signed by him. According to Judge Lilina, the prohibition to practice law applies only to judges who are in service and does not cover those who are in suspension. He also said that he was forced to practice law because of his impoverished life and because his wife and children are continuously suffering. So, what is the decision of the court? Judge Lilina Jr. is suspended and sternly warned. According to the court, by merely being suspended, judge remains to bound with the prohibition to practice law. The law does not give distinction between a suspended judge and an active judge. Moreover, he should not permit the law firm to still carry his name. By allowing the firm to do so, he held himself in public as a lawyer, and this is a violation of the rules and conduct of judicial ethics. And now for canon number 5. A lawyer shall keep abreast of legal developments, participate in continuing legal education programs, support efforts to achieve high standards in law school, as well as in the practical training of students, and assist in disseminating information regarding the law and jurisprudence. So in canon number 5, we can see the objectives of the integration of the bar. And these objectives are: number 1, to elevate the standards of the legal profession. Number 2, to improve the administration of justice. And number 3, to enable the bar to discharge its responsibilities effectively. After admission to practice, a lawyer incurs a threefold obligation. And these obligations are: number 1, he owes it to himself to continue improving his knowledge of the law. Number 2, he owes it to his profession to take an active interest in the maintenance of the high standards of legal obligations. And number 3, he owes it to the lay public to make the law part of its consciousness. For canon number 5, let's take for example the case between the concerned lawyers of Bulacan versus Judge Cornelius. The complainants charged administrative case against Judge Cornelius for the violation of the Judicial Code of Conduct. They said that the judge is borrowing money from her staff and the lawyers with pending cases before her. So the issue for this case is whether or not Judge Cornelius is administratively liable. Yes, Judge Cornelius is guilty of gross misconduct, aggravated by undue delay of rendering decisions and violations of the Supreme Court rules. She was dismissed from service. Under the uniform rules on the administrative cases in the civil service, borrowing money by the superior to his or her subordinates is a violation punishable by reprimand, suspension, and dismissal from service. At the very least, she should be admonished by dealing with hers or his subordinates in an improper way. More severely prohibited is borrowing money or property from lawyers or litigants with cases pending before the court. This is a serious charge under Section 8, Rule 140 of the Rules of Court. Also, under Canon 5 of the Code of Judicial Conduct, the old one, a judge shall refrain from financial or business dealings that could reflect adversely on the court's impartiality. Okay, so let's go to canon number 6, the last canon of this 4-part video presentation that I will be making for legal and judicial ethics class. So, this is still under lawyer and the society. Okay, so canon number 6 states that these canons shall apply to lawyers in government services in the discharge of their tasks. Okay, so what does this mean? So, canon number 6 makes the Code of Professional Responsibility applicable to lawyers in the government service. This canon guides them in the discharge of this official duty even-handedly, without fear or favor to any or all litigants, whether rich or poor, powerless or powerful, weak or mighty. For canon number 6, let's take for example the case between Suarez versus Platoon. Suarez was charged with sedition, which was subsequently dismissed. He in turn filed a case for arbitrary detention against Lieutenant Ornaiz. After the case was handed to Judge Platoon, after several changes in the trial judge and several refusals by the fiscals to prosecute the case, the issue here is, should mandamus compel the fiscal to reinstate the case? Yes, it is unquestionable that in the proper case, the prosecutor must reinvestigate in order to properly dispense justice. It is also important to keep in mind that a prosecutor is a representative of the sovereignty. He is only interested in the fact that the justice is served. And this also includes his refusing to prosecute if the innocence of the accused is quite clear. He is a servant of the law, and his twofold aim is to not let the innocent suffer or the guilty be freed. He is not at liberty to strike foul blows because it is his duty to refrain from doing so as much as it is to use legitimate methods of prosecution. Alright, so we successfully finished discussing Canons 1 to 6 along with some cases as examples. In the next video, I will be discussing Canons from 7 to 9, which will cover the duties of a lawyer to the legal profession. Bye-bye! Thanks for watching.